Science and the Scientization of Policy. And so we have four experts up here being led by Judge Michelle Childs, and I'll give a brief introduction to Judge Childs and then turn it over to her to run the show. So Judge Childs is a district judge in the District of South Carolina for the U.S. District Court for the District of South Carolina. She was appointed in August of 2010. She received her BS in Management from the University of South Florida Honors College, as well as her JD from the University of South Carolina Law School, and a Master's in Personnel and Employment Relations from the University of South Carolina's Darla Moore School of Business, as well as a Master's in Judicial Studies from Duke University School of Law. You have fuller bios in your programs as well. But the last thing I'll mention, something that's very important to us at the Law and Economics Center, is that Judge Childs is on our advisory board, and one of the judges who have given their time to really give us great advice and to help us structure programs like you have today and throughout the year. So thank you for your service on that board, and thank you for serving as a moderator today for our final panel. I turn it over to you.
Thank you. It's been a wonderful opportunity to be here with all of you. So, over the last couple of days, we've discussed key issues related to expert testimony, including empirical evidence, scientific methodology, peer review, policy considerations, conflicting expert reports, and of course, economics as it relates to the theories of science. You have also heard lots of concerns about the considerations for recognizing, understanding, and evaluating good science, addressing the reliability of science and scientific methodology, and the inferences to be drawn, as well as the ramifications of poor or junk science. Through our discussions here today of genetics, GMOs, economics, world politics, climate change, the environment, and emerging technologies, our esteemed panelists will delve further into the concerns about the evaluation and admissibility of scientific evidence and expert testimony as it applies to modern-day politics and ethics of science and implementing regulations in our difficult and critical role as judicial gatekeepers, particularly in cases with novel issues. Before I introduce the panel, I remind you that you may send in anonymous questions to Slido.com using #Destin2021, and I'll work them into our discussion. And now, before we begin the program with our panelists, I thought I'd do something a little fun. They are well-renowned, but then they've written a lot. You have their bios with you, but we'll have some fun facts about them later. So I just want you to think about this as you go through, and we'll have you all disclose who you think they are based on their presentations, if that gives a hint in any way. One of them actually played for college basketball. Another of them, when at law school, was the captain of the skeet troop shooting team, and was an All-American in that regard and beat military. One of them grew up on a commune and got interested in risk when his stepfather got interested in eating various types of mushrooms. So just hold that for later on in the panel. But now on to our panelists. I will begin with my immediate left. We have James Copland, who has got a BA from UNC Chapel Hill, Master of Science from London School of Economics, a JD and MBA from Yale. To my far left is Gary Marchant, who has a Bachelor of Science from University of British Columbia, PhD in Genetics from University of British Columbia, a Master's of Public Policy from Harvard University, and a JD from Harvard University. And in the middle, Blake Hudson, Bachelor of Arts from University of Montevideo, Master of Arts from Duke University Nicholas School of Environment, and a JD from Duke School of Law. As with the other panelists, each of them will give you about 8 to 10 minutes of opening remarks, and then we'll proceed to our discussion. All right, let's begin with you.
All righty, I think I'm first, and I'm just going to sort of, I think, try to frame some of these broad issues here. I mean, you've been through a bunch of panels, some of which have probably touched on or even focused on some of the things I'm going to talk about, but I sort of want to frame it up. I mean, the judge talked about junk science in the courtroom. That's a phrase that was popularized by my recently departed colleague, Peter Huber, who I'll allude to in a minute, who really sort of framed up some of these issues for the Daubert trilogy of cases in the 90s that led to, at least in the federal courts, and obviously the Frye standard's still there in some of your state courts, that led to the judicial gatekeeper function that district court judges are asked to do today. I wanted to sort of start with something I wrote about in the Wall Street Journal last May, and that was when Johnson & Johnson decided to pull its baby powder with talcum in it. This is a product that had been on the market since 1894, and a wave of lawsuits had started alleging that the product caused ovarian cancer. The lawsuits ultimately totaled billions of dollars. There's a cert petition pending on one of these now at the U.S. Supreme Court. And J&J obviously felt that it was worthwhile to pull this product off. I guess I've learned now that there's a substitute type of baby powder. All of us up here and most of us in this room probably had the old baby powder in our diapers when we were growing up. They've got an alternative now. But the point here is that shortly before J&J made this decision, there was a meta-study published in JAMA, the Journal of American Medical Association, in January 2020 that had followed 250,000 American women for 11 years and found no significant ovarian cancer risk associated with talcum powder use. The Centers for Disease Control and Prevention didn't list talc as an ovarian cancer risk. The FDA had consistently found insufficient evidence to mandate an ovarian cancer warning label. And so, I mean, I think that this tees up the difficulty of some of these scientific questions and the sort of errors that can manifest in litigation with speculative science, as well as the interplay between that and the sort of broader regulatory state. I wrote a book that was published last fall called The Unelected, how an unaccountable elite is governing America. It's not as populist as it sounds. It's based on a piece I wrote in the Manhattan Institute City Journal, The Four Horsemen of the Regulatory State, and it really tries to tie together what I call the rule makers, the people who write regulations, the enforcers, because enforcement agents often drive the law outside in the federal context, the contours of the Administrative Procedure Act, and then the litigators, which are often underappreciated as an adjunct rule-making body that exists in parallel to the other regulatory state. And in certain contexts, my argument would be that the litigation system, while it generates compensation, effectively acts as an overcorrection, generating effectively deadweight loss along with redistribution through the process. Because in the context of something like the FDA, there's a significant amount of evidence that the FDA already has a substantial type 1 versus type 2 bias. Which means that the FDA is generally costing more lives than it's saving through its review process due to delay. And it's something we've seen vividly in the last year. It's important to remember that 2 days after China released the genome for COVID-19, 2 days after that, Moderna had its design for the vaccine. Yes, and I had that shot 2 weeks ago, and I'm glad to have gotten it, but I would have loved to have gotten it a year ago. And so the point is not that we don't necessarily need an FDA review process. I think we do. But the point is that there's a significant slowdown in innovation that costs lives through that FDA review process. And then we have product liability litigation on top of it. And significantly, that product liability litigation is often predicated on what my colleague Peter Huber liked to call junk science. Peter Huber, he's somebody, I always say there's smart and then there's Peter Huber smart. All of us in this room are smart. Peter Huber got his PhD in mechanical engineering from MIT at the age of 23 and an assistant professorship the same year. Was tenured 2 years later. 1 year after that started Harvard Law School. Was the only person in a 20-year span to graduate summa cum laude from Harvard while he was teaching full-time at MIT as an engineering professor. At the same time, he was doing his coursework at Harvard. You know, and Peter, after clerking for Ruth Bader Ginsburg and Sandra Day O'Connor, we hired him, or my predecessors hired him in '85. 1 year later, the government turned to him to figure out the telecom system. They had to generate a report after the breakup of AT&T. No one could figure it out. Peter wrote a 450-page treatise on this. projecting essentially all these devices that we have today and where that was going, and he did it in 11 months. So, you know, this guy is incredibly bright, and 1 year after that, he wrote his first of multiple books on the litigation system and the interplay between science and the courts, called Liability, the Legal Revolution and Its Consequences, and then follow that up 3 years later with Galileo's Revenge, Junk Science in the Courtroom, which was cited by Judge Kaczynski in the remand in Dalbert v. Merdau. Now, when we look at Dalbert, I mean, it's important to realize, you know, this is a paradigmatic junk science case flowing from Bendectin. And what do we know about Bendectin? We know that it was used by a quarter of all expectant mothers in 1980. 3 years later, Merrill Dow Pharmaceuticals faced $18 million in annual legal bills, only had $20 million in sales of the product. Clearly, this is going to lead, just like with J&J and talcum powder, a producer to pull this off the market. There have been more than 30 subsequent published studies examining over 130,000 patients, failing to find a link between Bendectin and birth defects. And there are real health effects of this. The percentage of pregnant women hospitalized each year for morning sickness doubled after Bendectin was pulled from the market. That's hospitalized morning sickness. This isn't just the stuff that, you know, that our wives or ourselves have had, you know, going through the process. Morning sickness is common. Hospitalization for morning sickness is something else entirely. 30 years later, 2013, Bendectin reintroduced to the market. It remained on the European market throughout this time. You know, the other case that was sort of percolating through was the Dow Corning case. And of course the breast implants. I mean, again, you know, it's a more frivolous thing than hospitalizations, et cetera. But in 1995, 400,000 women registered for a fund, more than $4 billion. Corning had started losing all these verdicts. And while this was going on, studies were being published showing that the breast implants were actually associated with a lower risk of breast cancer. And the seminal epidemiological study in the New England Journal of Medicine found no association between implants and the connective tissue diseases that were the predicate for the lawsuit. So, I mean, a few points I just want to flesh out at the beginning, and then we'll hand this off. One, a lot of this flows from our rules of procedure. You know, our system evolved. You know, tort was a backwater. Oliver Wendell Holmes in 1871 said, it's not even a proper subject for a treatise. And then in the 1930s, there was this merger of law and equity. And all these liberal rules of pleading and civil procedure, et cetera, were imported from the equity courts into the law courts at the behest of Charles Clark's committee for the Rules Advisory Committee, the dean of the Yale Law School. And after that, you know, we had the modern sort of second wave litigation explosion that my former colleague Walter Olson has written about. And really some of this evidentiary gatekeeping is sort of the aftershock of this, because the old rules of law, and you know, my granddaddy's law books are on the shelf in my house. They have separate cases in law and equity. We don't have that anymore. None of us grew up learning this. But the old rules of law really narrowed the questions before the jury. The modern situation is quite different. Even simple questions of fact can be miscast to a lay jury that faces a sympathetic injured plaintiff. And we want to talk about it. We can talk about something as simple as the sort of coffee study that was done by Reed Morgan, the Texas attorney in the Stella Liebeck hot coffee case, which is sort of the seminal case. I read this in one of the chapters in my book, and explain why, you know, the study was just wrong, and what was presented to the jury was just wrong, and it drove that verdict. You know, again, not as big, a bigger verdict in the public imagination than in the actual economics of it, but it just sort of shows that even a simple sort of case like hot coffee can have scientific evidence errors. The litigation process, can it override administrative judgment? We can talk about Wyeth v. Levin if we want, you know, but that's obviously the standard here. Those of you in state courts, though, that doesn't mean that you don't have some significant discretion in some cases, particularly in the common law space, over what your common law looks like. So just because the Vermont courts decided to do this on a failure to warn theory in Wyeth v. Levin, you don't have to. And the public health consequences can be massive. And this goes back to the vaccines. You know, it's ironic. ironic that the Vaccine Injury Compensation Program set up in the 1986 statute by Congress is so much to the fore now. But even this area has been infected by some sorts of junk science and the like. The thimerosal litigation that about 2 decades ago was really percolating and creating problems with the flu vaccine market. So I just want to leave with a quote from Peter Huber on this that I think is sort of important. And he wrote this about 14 years ago when he projected what he called the coming next pandemic. And Peter said, germs no longer need to be smarter than our scientists, just faster than our lawyers. And that's where we are today.
Thank you. We'll move on now to Mr. Hudson.
All right. Well, hello, everyone. Thank you so much for having me here today. I always enjoy engaging with the Law and Economics Center, and I appreciate Donald Cochin and the organizers asking me to be part of this panel. I've been thinking for some time about how, like much of our public discourse, science has become politicized, and vice versa, as the title of this panel suggests. And I use science broadly here, and I think I'll have some support here to include the use or misuse of economics to support political positions. Consider the recent case of freezing temperatures in Texas, right, where some politicians and media sources were quick to blame the failures on wind turbines, despite the fact that wind energy makes up only about 25% of electricity capacity in Texas. Between 2/3 and 75% of the outages were attributable to natural gas and coal facilities that did not have proper winterization protocols in place, which is a problem that was also shared by the wind turbine operators. Another factor was the deregulated Texas energy grid and the fact that spot market prices for natural gas increased exponentially during the crisis. So a power company board member that I know in Florida, when they were trying to decide what to do with the Florida natural gas about releasing it to Texas, said that the rolling blackouts in Texas were partly a political choice to keep people from revolting when their energy bill was $5,000 after the crisis was over. My brother's bill was $5,000 because he had a backup generator that ran on natural gas. And so these blackouts were aimed at keeping it at $1,500 instead, right? So just to pull out some fake terms there, or numbers there. But somehow wind turbines and the Green New Deal were to blame, right? For the and this is kind of that intersection of science and economics and politicization, politics. But the lack of nuance on the complexity of scientific and economic phenomena often cuts in the other direction, politically, so to speak. Imagine environmental activists that support coastal restoration, or the restoration of river systems that benefit salmon, or that environmental groups that oppose cutting down forests. They resist land development initiatives or seek to have coal-fired power plants shut down. These are exactly the types of causes one might expect environmental groups to take up, but what if by doing so, environmental groups are doing more harm than good? What if this activism results in stranded assets in the coastal zone as sea levels rise, more carbon dioxide in the atmosphere, or increased urban sprawl? Sometimes those who support environmental causes undermine their own position through oversimplistic scientific viewpoints or purposefully uninformed positions for strategic reasons, fundraising reasons, and the like. And this is something that I have called environmentalist denialism, when environmental groups deny science because it may be at odds with the inertia that carries their organization toward a particular political position or viewpoint. And I want to discuss 3 examples that I think demonstrate the point, and I'll close with just a couple practical things that are somewhat obvious, but the practical applications for what to do about it. First, I think about the Louisiana Coastal Master Plan. So the state of Louisiana has the highest rate of relative sea level rise in the world. What that means is that the Mississippi River used to change course throughout history, and it would deposit sediments along the coastal area, build up sediment, build up land. But as soon as we levied the system up and sent it out, we sent all that sediment out to off the intercontinental shelf, the land is sinking. So there's no more building of land. At the same time that the land is sinking, sea levels are rising, right? So the rate of relative sea level rise is the greatest in Louisiana of anywhere. And so the state of Louisiana said we're going to come up with this coastal master plan to restore the coast. We're going to sink $50 billion of somebody's money. Yay, BP spilled some oil in the Gulf. Now we have a fund to actually fund some of this. We're going to put that into coastal restoration, which might include creation of barrier islands, sediment diversions from the river systems to try to restore the building of sediment up, and things like that. 86% of Louisianans supported the Louisiana Coastal Master Plan, even though I guarantee you 86% of Louisianans are not card-carrying members of the Sierra Club, but they did want these projects to take place to save the coast because they don't really care why the coast is going away. They just know it's going away. And the problem, though, and a lot of environmental groups have gotten on board with this. Hey, coastal restoration, what could be bad about that? We're going to save the coast. The problem is that the same environmentalists that support this are effectively climate change deniers when you look at some of the emerging science that's not particularly popular among Louisiana politicians who want the support of 86% of the population. Some of the science is showing that sediment diversions either will be too slow to build sediment at a rate that can keep pace with sea level rise, or you're actually hastening the decline of land building because turns out if you dump a bunch of nutrients into a wetland, it kills the wetland for the same reasons that you get eutrophication in the Gulf of Mexico. And so it's a tension right now between science that a lot of environmental groups are like, no, we have to stop this, the coast from going away. We're going to build habitat. We're going to do all these things. And you may be throwing good money after bad by not instead investing in retreating from the coastal zone through adaptation policies. And so that's an area where there's this denialism about what the science is saying because it doesn't fit with what your typical worldview might otherwise be. Another area that's close to my heart that I work on, I grew up in timberland about 2.5 hours northwest of here in South Alabama, is the issue of wood pellets for electricity generation. As you all may be aware, Drax Biomass in England has shut down, I think now 5 of their 6 coal-fired boilers, and they're using wood pellets to fire those boilers for electricity. They're getting almost all of those wood products from the southeastern United States. It would not be possible but for, economically feasible, I should say, but for big subsidies from the English government. They basically take all this down timber or excess timber off forest land in the southeast, or from wood chipping mills and things like that. They pelletize it and put it on barges and send it 21 days over to England. And a lot of environmental groups and organizations have been, Bill Schlesinger's one who's written a lot of articles criticizing the industry, have been concerned about the effects of wood pellet markets on climate because you're still emitting carbon dioxide into the atmosphere. And these scientists, in my view, have been cherry picking which scientific assumptions to make. A lot of times they say it takes 100 years for this carbon to get recaptured by a tree, but they're not taking into account that most of the trees grown in the southeastern U.S., the loblolly pine that you see, or the hybrid pines, can recoup that investment in about 15 years, right? And instead of 100 years, they kind of take the worst case scenarios and presume that that's going to be rampant and widespread. And my argument has been, look, we need to do a better job of modeling carbon dioxide because in the southeastern U.S., 86% of forests are privately owned. They are assuming that if you don't have a market to cut those forests, then they're going to stay forests, and that's a very wrong assumption. If you don't have a market for people to put their timber into in the southeastern U.S., you're not going to get a lot of state government regulation to protect those forests because you don't have any regulation of private forest management. It's mostly voluntary best management practices. And people are going to turn their forest into a soybean farm. And so what I've been trying to encourage through my research is to say we need better modeling to take into account the effects of not having a market like this on the timber landscape. Because you could it may be better off burning trees for energy and then displacing fossil fuels in the process and then recouping that carbon dioxide in a closed loop cycle than to have no trees at all, right? And so that's one area where even though I'm a conservationist and I tend to agree with these groups, I think they're treading in the wrong direction on this particular topic. Third, the Ninth Circuit last year decided a case titled U.S. Forest Service versus High Cascade Incorporated. The case was issued as a memorandum opinion, so it has some precedential limitations. Nonetheless, the case involved a Forest Service program to reduce the risk of wildfires and promote safe fire suppression activities. The plan called for variable density thinning, where trees of a variety of sizes would be thinned to reduce fire risk. And a lot of you again, another political debate recently was the western wildfires are all climate change or no, they're all forest management decisions to not get these fuel loads out of the forest, when in fact it's both issues, right? It's bad forest management. Smokey the Bear has been terrible for our nation's forests. They should have let them burn early on. And then you've got, on the other hand, you've got climate change that's drying things out more quickly and causing it to burn. So despite the relatively settled science on the techniques the Forest Service planned to use, the environmentalist plaintiffs were able to convince a 3-judge panel that wildfire risk reduction, about which there's really very little real scientific debate, was highly controversial and therefore required the preparation of an environmental impact statement under the National Environmental Policy Act. Typically, this would be a case where a simple battle of the experts, which many of you probably have said in some of your own cases, that we're going to defer to the agency under Chevron on this battle of the experts. If the Forest Service has to prepare an EIS, however, every time it wants to protect communities and natural resources from wildfire, I think we'll end up burning up countless homes and essential man-made natural infrastructure. So coastal restoration, preserving forests sound good, but when engaging in these activities would be worse for the environment based upon sound scientific or economic analysis, these groups need to be called to task, I think, for their lack of nuance. So what does this mean? I'm going to wrap up. For policymakers crafting regulations, lawyers advocating in these cases, or judges deciding them, these points I'm going to make to close seem obvious, but I think they need to be stated as a practical matter. We need to seek to understand better how an advocacy organization's worldview might blind it to the scientific or economic reality, whether it's those opposed to wind turbines or supporting them. We need to review a wide swath of scientific literature and economic analysis, and don't assume that an organization with a generally sound scientific bent is always utilizing the correct science. And I don't mean giving equal weight to the 1 or 2 debunked scientific articles claiming that climate change isn't happening. I mean, as in the context of wood pellets, there's legitimate scientific debate that can be uncovered among researchers as to the effects of wood pellet use on the carbon cycle. Respectable bodies of literature across the spectrum of viewpoints. And then finally, one of the projects I'm working on is creating a repository for unpopular science or policy debates that are legitimate, or scientific debates that are legitimately unsettled. I've got a environmentalnarratives.com where we kind of take on some of the narratives that are created by environmental science and policy and kind of give the hard truths that people don't necessarily want to hear. And I think much as George Mason does with their climate change communication program, the Maine University, I think we need to do a better job of having a place where people can go vet what are true scientific debates and what are debates that are more or less settled. So I'll close with that.
Okay, Mr. Marchant.
Great. So this is a topic I'm really love. I've been sort of working on sort of this issue of separating science from politics for a long time. I've written some articles. I've testified to Congress on this very issue. I've written an amicus brief in the Supreme Court on this very issue. And I was really motivated by sort of 2 fundamental things I read early in my career that really convinced me of the importance of separating politics from science. One was a National Academy of Science Committee report in 1983 called Risk Assessment in the Federal Government. It's called, sometimes referred to as a red book. It's sort of the Bible of risk assessment. And basically the key lesson in that is you have to separate the scientific process of risk assessment from the policy aspect of risk management. And if you don't separate those, you get into all kinds of troubles. And so things like economics, things like values, things like fairness, things like public policy, things like politics, these are important. You know, this is the Law and Economics Center. Economics is important, but separate it out from the science. See what the science gets you. Where does it get you? It won't answer the question, but address that first and then go on to the policy, economic values, fairness, all these other important aspects as well. And to me, it really made a compelling case for that. And then the second influential thing I read was a law review article by a law professor named Wendy Wagner in the Columbia Law Review in 1995 called The Science Charade in Toxic Risk Regulation. And she talked about how, and she had worked as an EPA attorney, that there's this incentive now to say things are scientific when they really are normative or policy. And it basically does a lot of good for agencies. They basically can bamboozle Congress. You know, the administrator of EPA will go up to Congress and say, you know, Senator or Congressman, this is a scientific matter, and therefore, you know, I have no choice. And the the Congress people's eyes glaze over and they can't challenge her. You go to the courts, and under precedents, courts are supposed to be deferential to a regulatory agency's scientific determination under Baltimore Gas and other cases. So again, the court's hands off if you say it's scientific. The media, if you go and tell them it's scientific, they buy it. Yeah, we accept that. We're not going to second guess you. And the public also gets bamboozled when you say it's scientific, what's really a normative decision. I remember once when I was a practicing lawyer, I was representing a company in California for a hearing on whether a facility should be permitted, and obviously I was in favor of getting permitted, but I was sort of put back by the EPA speaker, who also wanted it permitted, gave this talk to the public, and it was all quadratic equations. All these formulas of risk assessment. That's not the reason they're permitting it, but it completely shut up the audience. They just didn't, I don't know, quadratic equations. So it was very anti-democratic to me to not really talk about why this facility is an important facility. So that was another very influential article, and the combination of those really convinced me, and that's why I sort of started along this track. There was a great natural experiment. We talked about natural experiments, our statistical speaker yesterday, in Europe, because they were, had all these sort of science committees that were saying GMOs are dangerous for a few years. And it seemed kind of bogus to me. GMOs is what I'll get to in a second. But after things like mad cow and they had some dioxin in chicken, they decided to create their own FDA. They didn't have a federal, EU-wide regulatory agency to regulate food safety. And they came forward with a proposal, and then the European Commission said, under basically the Constitution, the Treaty of Rome for the EU, you can't talk about risk management and policy issues as a new entity. You can only talk about the scientific matters. So by this legal ruling, they had to create this agency that only considered science. And it's called the European Food Safety Authority. It's been a tremendous success. It's been incredibly effective, incredibly influential, incredibly credible. And for example, on GMOs, they've now looked at about 50 different ones and found no risk on any of them. It drives the politicians and the agencies in Europe nuts because they still want to ban this stuff and are banning it. But their own scientific agency is now saying there is no evidence, scientific evidence of risk. Some other things are more anti-industry, where they come up with they're a straight shooter. And they have this very strict way of operating, that they operate according to scientific principles and methods. And no policy things are allowed to influence their decisions. And they do a great job of it. It's incredibly effective. So I think, that to me is a great lesson, that this can be done to separate the science and the politics. The example I want to throw out there is GMOs. I'm an unabashed supporter of this, I have to admit. My kids no longer go grocery shopping with me because I'm always getting in a fight with the people at Costco who say no GMOs in this food. And I ask them, why is that a good thing? And they, of course, don't have any good reason. My kids get embarrassed. But the reality is it's just astonishing if you dig into this case study. There's been over 2,000 studies published in incredible journals, all finding there's no risk. There's nothing else that has that incredible record of. There's almost always noise in any other chemical or thing you study if they're relatively safe. This is just incredibly clean. Now there's a small group of scientists who have a PhD who work with advocacy groups who publish stuff in some of these predatory journals I talked about a couple days ago that's pay to play. You pay $5,000 and they'll publish it within a day, peer reviewed, they claim. These are not very credible studies. The National Academy of Sciences had 4 studies on the safety of GMOs. The last one, they invited all these scientists who claimed there's a problem, and it's literally, you can count them on 2 hands, and rejected absolutely what they said. They said it was not at all credible. The conclusion of this report is that the committee found no substantiating evidence of a difference in risk to human health between currently commercialized GMO crops and conventionally bred crops, nor did it find conclusive cause and effect evidence of environmental problems from GE crops. GE crops have generally had favorable economic outcomes for producers in early years of adoption, but enduring and widespread gains will depend on institutional support and access to profitable local and global markets, especially for resource-poor farmers. The American Association for Advancement of Science has given a clean bill of health, the American Medical Association, the World Health Organization, over 30 different scientific organizations have concluded that GMO foods are as safe as conventional foods, if not safer. They're the only foods we test for safety. None of our other foods have to go through any safety testing. The only foods in our diet that we test for allergenicity is every GMO food goes through a battery of different tests. These are the one foods we know are not allergenic. None of the other foods are tested for allergenicity, and yet you hear these claims that by some of these supporters that they are there's an allergy problem, and there absolutely isn't. It's been proven they've been tested. And what's going on here? And I'm not a conspiracy theorist, but there's a conspiracy going on. The organic food industry, every single one of these groups is funded almost 100% by the organic food industry. You could trace it publicly, and I've been doing that. This organic food industry is a $50 billion industry. It dwarfs the GMO industry in size. And the reason people buy organic foods is not because of price, because it costs twice as much as other foods. It's because they're scared of other foods. And they say that openly in their internal, so I've gotten on a lot of their mailing lists. I shouldn't say it publicly because they'll cut me off. But they say the only way we can get people to pay for organic foods is if they get scared of other foods. And nothing scares them more than genetically modified foods. And so now we have a situation where this is the biggest gap between science and the public on any issue that's been looked at. The Pew Institute recently did a study of the difference between public and scientific views, and 88% of the scientists support the claim that GMOs are safe, only 37% of the public. So, who are those people who are going to be on juries now who have this fear of GMOs, and where is that coming from? There's huge environmental benefits, there's huge humanitarian benefits. This is an amazing technology, but because of this public fear and concern, to get a GMO approved is an extra 10 years and $100 million of safety tests that a non-GMO food doesn't have to go through. It completely has delayed so many beneficial products by 10 years. So, I think this is an example where this is clearly a political agenda that's basically blocking an incredibly beneficial product from us, but more importantly from developing countries. I'll just close with a quote from a recent article in the editorial in the Washington Post by Mitch Daniels, who is the former governor of Indiana and currently the president of Purdue. He says, and yet a concerted deep pockets campaign by the organic industry, doesn't say that, but that's who it is, as relentless as it is baseless, has persuaded a high percentage of Americans and Europeans to avoid GMO products and to pay premium prices for non-GMO organic foods that in some cases may be less safe and less nutritious. This is the kind of foolishness that rich societies can afford to indulge, but when they attempt to inflict their superstitions on the poor and hungry peoples of the planet, the cost shifts from affordable to dangerous, and the debate from scientific to moral. That there's all these types of foods in places like Africa that could help, and they're being blocked because of this opposition to GMOs that's coming from developed countries. So that's, to me, a great example of how politics is distorting science.
Well, very robust discussion to start with. I'll start with a couple of the questions in the chat, and then I'll have some questions for our panelists as well. First, will the expedited approval of the COVID vaccines change the process used by the FDA? And I believe that will be for you.
If there's political will, I sure hope so, right? I mean, there've been improvements. I don't want to suggest. Just as in the courts, there've been improvements. Since the '90s, since the Daubert trilogy of cases. There've been improvements with the regulatory process. My colleagues in healthcare that I've worked with for years have done a lot of work studying PDUFA, where you can sort of fast track. And basically, it's basically utilizing a sort of almost a pay-to-play system, but when the stakes become higher, you can prioritize your drug movement. There's been a right to try type legislation that's enabled much more, and a lot of these things flowed from say the last epidemic we had, the AIDS epidemic or pandemic, where there was an enormous push. From concentrated interest groups to speed up the process, which was truly life and death. I do worry about the slowness of the process when it comes to the next virus that hits us, right? This virus has killed 500,000 people in this country, but what if the CFRs and IFRs were twice what they were, right? It could have become extremely fast. It could have spread extremely fast. And the irony is we had the technology, it doesn't mean we have the ability to upscale that technology instantly. A lot of things come through manufacturing and distribution. This was the critical error that the FDA and CDC made in the front end of the pandemic. I'm not sure in hindsight it's quite as important as I thought it was at the time, because it seems like the virus has taken root everywhere, right? So it's not as if we were going to keep this virus out. But the early testing, why was the U.S. really bad really early. In part, we had no ability to do contract tracing, no ability to do aggressive testing of the sort we did at this conference, the mail-in PCRs, the rapid testing, et cetera. And why was that? It's because the CDC had the monopoly grant from the FDA on our testing process. They didn't use the one developed by the WHO. And there, in addition to errors in the test, there were critical failures and choke points in the manufacturing process that made it impossible to mass produce tests. So South Korea was getting tests out 100 to 1 as fast as the US by February, and we were way behind in some of this. Now, and again, it's precisely because of these sort of regulatory choke points. So I hope that, as we saw with HIV, that this viral pandemic will lead to substantial rethinking of the FDA. It's hard because the regulators do have that type 1 versus type 2 bias. If the regulators, the regulators are going to get pummeled worse generally for the next Vioxx, where there's an unknown side effect that isn't discovered and then manifests later. They're going to get pummeled for that much more than the general slowdown, which ultimately is going to cost more lives in most cases, right? So I hope there's that process of rethinking, but we still have all these other problems like our tort system and everything else that are sort of a parallel regulatory track.
And there's a huge flaw in the way we regulate diagnostic tests. So we have two different systems, if you don't know. About 95% of diagnostic tests are regulated as laboratory developed tests. They're not subject to FDA regulation. FDA says they have authority or jurisdiction, but they're not exerting it, although they keep on talking, maybe they will. And those ones are laboratories that develop the test as a service. And they are allowed to put a test on the market tomorrow, as long as they're convinced it's good. And they're regulated under CLIA. It's a process rather than a pre-market approval. And the reason these laboratories advocate for continuing this system is because they can move very quickly. The other tests are regulated by FDA. It takes them a couple of years, 2 or 3 years. But once there's an emergency declared, now the LDTs, the laboratory developed tests, are not allowed to put their tests on the market immediately. They have to now go through FDA approval. So we're actually slowing down the approval when there's an emergency. It makes no sense. It's completely paradoxical. And I think people all recognize this now, so there's going to have to be a change. But this should have been predicted that why would you make them in an emergency have to go through a lot longer process than you do in a non-emergency? It makes no sense whatsoever.
And then Professor Hudson, with respect to climate change, it's taken a long time for the public to kind of come around just on that issue and accepting the science. So just kind of compare that to COVID, the politicization of COVID-19. Do you believe that judges, jurors, the public will take some time just because that's been a political hotball?
Well, I think it's interesting to consider. One of the things that we've been saying for quite some time about climate change is that the results, the negative effects are not necessarily immediate, right? And there's always somewhere else you can point, I think, with climate change. Even when you think about, you think about the Western wildfires. Like, well, look at the chart showing the increase in wildfires out west, the acreage burn, things like that. You look at the frequency of the hurricanes and whatnot, and you're like, surely now people will realize it. But then you get people saying, no, it's just because there's a lot of fuel loads on the fire. Fuel loads in the forests. Or hurricanes have always happened and they always will happen, kind of thing. And so I think that COVID, the fact that COVID itself has gotten so politicized, to me, doesn't necessarily speak well for the public's acceptance of climate change science. And I think that's just going to take more of a cultural shift, maybe a generational shift in how people parse information and parse news sources. In my own family, I see the people who thought Walter Cronkite was, the voice of God, don't realize that the news has changed and that it's not this neutral arbiter of, if it was then, it's definitely not now. I think that, the skepticism maybe of the younger generations of being careful about what sources they're listening to and what where that news is coming from and trust in the science, I hope will make a difference. But it's actually, some people were saying to me that, well, the COVID, the pandemic is going to help spur people's acceptance of climate science, and I kind of view it the other way in saying that if people can doubt whether folks are dropping dead in hospitals based on a virus, then how much more are they going to continue to doubt the realities of a changing climate?
Okay, and then Professor Marchant, do you happen to have an opinion about the safety of GMOs?
Oh, I got an opinion on it. I mean, so, like anything, there could be dangers and risks, but the fact that these go through 10 years of safety testing by 3 different agencies is not surprising. There's never been a documented case of any harm from a GMO. Whereas I think I mentioned a couple days ago, my pet hobby is I keep a file of people being killed or hurt by organic foods. Over 1,000 people have been documented killed by organic foods. It has higher levels of all kinds of potent carcinogens and food poisoning in them. I mean, so if you're looking from a food safety perspective, take the GMO, reject the organic. I still will eat organic if I have to, but the GMO is proven safe, and yet the public has just the opposite view. And just one other thing. So I was once interviewed by our local TV station about cosmetics and safety and risk, and she says, do you have any other interesting stories? And I gave her my organic spiel, and she says, oh, that's fascinating. She comes back and says, no, our station manager says we can't say anything bad about organic food. Too many people like it. So that's our world today.
And do you happen to have any opinion about the politicization of climate science?
It is a very politicized issue. I mean, I believe that we have climate change, but it's become very politicized, and a lot of the scientists working on it, they get passionate about it, and they get politicized in there. They got a lot of emails were hacked in a case a few years ago where they're showing, climate scientists are deliberately, smearing other people and trying to manipulate the process. It's a human tendency. And so if you allow scientists to be people, they're going to be political, and they're going to bias their results. That's why you need to put in place the structure. The system of science tries to wean that out the best it can. So yeah, I think climate change is a big problem, but I think it does get very politicized by both sides.
And then, go ahead, you had a comment on that?
Yeah, I mean, I think as big as the organic food market is, and as big as that industry is, I mean, orders of magnitude larger when you talk about the climate change on both sides of this. That's both the fossil fuel industry, but also the sort of green technology industry, the solar, the wind, the private equity money flowing into that. There's enormous money on both sides of this. And of course, the costs are huge. I mean, there's an interesting interplay between the other two panelists' ideas, right? Which goes back to a point that Peter Huber made in Hard Green, saving the environment from the environmentalists. GMOs and this whole fight for organic food and the whole locavore food movement, that is in fact in significant tension with worries about the climate, because the actual yields that GMOs help generate mean that you can produce a lot more food on a lot less land, which means that, of course, you can put more trees down and have more carbon dioxide put back in the natural way into the environment by having less farmland with the same output. So these things can intersect. I don't think that judges are particularly well equipped to wrestle with all of this. And it's not because you guys and gals aren't smart. It's just because this is extraordinarily complex, and these policy issues are daunting. And you've got a case in front of you with advocates on both sides with a narrow issue. So where I particularly worry is, judges are going to try to fix this with a theory of public nuisance law that's imported, from the 1400s, rather than letting the regulatory agencies sort it out. And of course, the regulatory agencies are going to be subject to politics because they're appointed by people that get elected in elections. But these are complex questions, and even if, let's say, you had a climate policy that reduced carbon emissions in the United States, that may or may not, in fact, help the problem at all. It's going to only help it on the margin if it does, but you also might be substituting inevitably for something manufactured overseas with worse carbon emissions. So it's a very complex problem that requires global type thinking and solutions, and that makes it very tricky to try to figure out in the context of a litigation in American courts. Now, if there's a statute with a private right of action, you've got to then try to interpret the statute and interpret the law and interpret the regulations, et cetera. I mean, that's what you're charged to do, but I think these free-flowing sort of old public nuisance type approaches are really misguided.
Professor Hudson?
And I just want to clarify, because I don't want to leave you with the sense of, because you could hear some of what we've been saying and say, oh goodness, both sides are spinning it equally, and is it still a close call, or whatever on climate science. And I want to try to draw a distinction between some of what you're talking about, Gary, with the emails and whatnot. There's a difference between the complexity of the modeling of future impacts of climate and then the straightforward, simple science of ocean acidification and going out and figuring out how much the oceans have how much acid the oceans have, more acidic the oceans have become because they're absorbing carbon dioxide. That's a simple science experiment test that's not debated. There's also pretty settled notions of how many parts per million, based upon the fossil record, carbon dioxide was. And you judges, you focus on logic and common sense. Go look at the chart of what historically the carbon dioxide levels were, understand the basics of how the greenhouse gas effect works, and ask yourself if it's good that the last time the carbon concentrations were this high, there were alligators in the Arctic. Okay, I mean, it's just, there's some things that are more settled than others on climate science, even as far as where we are and how cautious we should be. And so I don't want you to get the impression that everybody's gaming the system on both sides equally or whatever. There's some common sense conclusions you can draw, and then recognizing the complexity of, well, what does this mean going forward? And there's a lot of things that we don't know. There's a lot of feedback loops that could occur. You know, maybe we have more cloud cover that reflects more solar radiation back into the atmosphere, and therefore it's not as bad. These are the debates where I think there is some potential bias going on, even in the scientific community. But you can ask yourself whether we're in a good spot or now, and feel pretty sure about the answer you get to just by looking at the concentration of carbon dioxide in the atmosphere, higher than they've ever been in human history, since humans have been on the earth.
And just as one follow-up to the GMOs, Professor Marchant, and then we'll move on from that topic, how would you address the claim that GMO foods may be harmful in such ways our technology is not yet advanced enough to detect?
Well, so we study it by looking for any adverse effects in animals and humans. And so if there is going to be an adverse effect, no matter what mechanism it occurs by, you're going to see it when you study animals and you study humans. There's nothing there. Nothing happens bad.
Okay.
I mean, so you don't have to worry about what mechanism could cause that harm. I mean, it's just like the climate change. You know, the atmosphere is we can measure, it's higher. That's a fact, so that's, then you can argue about what the implications are below, but that's a fact. The fact is people and animals are not harmed by eating GMOs.
Okay. And Mr. Copland, you've been a critic of the tort system on pharmaceutical litigation, but as well you've been an advocate for broader preemption of claims given the federal regulatory oversight. Can you please explain your views in that regard?
Sure. I mean, there's an interaction effect, right? I mean, you've got two parallel regulatory regimes, and so the FDA is making these decisions, and I have argued and am arguing that the bias here is toward overregulation at the FDA. In other words, the FDA slows down the process. That costs more lives than it saves. But then on top of that, we have a tort regime. Now, sometimes the tort regime is picking up real side effects. I mean, they're not all Bendectin, breast implant, thimerosal types of cases. I mean, with vaccines, there in fact are side effects that can be fatal in children. I mean, so the Vaccine Injury Compensation Program sort of highlights some of the problem with that. We want people to take vaccines. We want them to vaccinate their children. That provides herd immunity. But every so often, there is going to be a real side effect. Now, it's not going to be autism, right? I mean, that was the claim made in the Lancet by the Andrew Wakefield article in the 1990s that was later retracted, that the MMR vaccine causes autism. So it's not that, but there are side effects that can happen, and that's probably true of the vaccines people are taking now for COVID. It's just that the risk from COVID is way higher than the risk from the vaccine. And that's true basically for all these vaccines. And that's the point, and that's what the tort system particularly doesn't do a very good job of teasing out. And Peter Huber wrote about this too. I'm going to keep quoting him, but he talked about it. The jury's looking at the adverse impact of the vaccine, but it's not looking at the coughing up of blood and the skin falling off and all the sorts of things these classic diseases would cause. I mean, it's not weighing that. If you're having a lawsuit over the Sabin live polio vaccine, they're not weighing the cost of polio versus the cost of the vaccine, right? They're looking at that specific case, which is why you get this massive overcorrection in the tort system, because it becomes basically an insurance system against the adverse event. Whereas the regulatory agency is trying to do that cost-benefit analysis and say, well, yeah, I mean, the vaccine has some risks, but boy, the risks on the other side are way greater, and we want to green light it. And so that's why the tort system just doesn't do a good job of that at all, and it recurs and recurs and recurs. And we've carved vaccines out with a separate compensation program, but for and that's particularly defensible because there's a public health interest, right? I mean, go around here trying to fight to get people to wear masks or whatever, or take a virus seriously. I mean, precisely because these things become politicized, because your neighbor can influence you when it comes to a pathogen that you can get infected with. Precisely because of that, vaccines are, as a prophylactic or preventative, particularly different than someone getting a treatment post hoc, which is going to have much more internalized benefits, and so the cost-benefit analysis is more internalized. But I think the evidence is pretty strong that the type 1 bias predominates over type 2 with FDA regulation, and then the tort regime is on top of it, and we saw that in Wyeth v. Levin, right, the seminal case. Now that may be correct as a matter of law. I mean, Clarence Thomas may be correct. Maybe implied conflict preemption, is something the court should never do. If Congress wants to preempt, Congress should say so expressly. They certainly have the power to do it. That might be the legal outcome that's correct. But what you had there was Phenergen, a drug that you injected into the vein, and it was very useful, but if you put it in the artery instead of the vein, it would create gangrene. And the FDA went through that product over decades. I mean, this wasn't a new drug. They went through that product over decades and came to the conclusion, well, the costs outweigh the benefits of this drug outweigh the costs, put big warning labels on it. They had the warning label in 4 places, all caps, in bold, warning, intra-arterial injection may cause gangrene. This was on there, and what happens in Vermont, I mean, a physician's assistant misses the label, messes up, puts it in the artery, settles the case quickly, and then says, oh, well, if I'd seen a different warning label, I might have been able to, not do that. And that person, who happened to be a musician who lost her arm, was very sympathetic to the jury. That person would still have the arm because I wouldn't have made that mistake. So what you end up doing is having that jury in Vermont second guessing that cost-benefit analysis that was done over decades by the FDA back and forth with the industry for a product that's relatively low value, and you ultimately trump it, and that's the decision of the Vermont Supreme Court. If we've got a Vermont Supreme Court justice involved in that decision that's here, I'm sorry, but that's just a preposterous ruling. But because what you're doing is second guessing this entire regulatory process over a failure to warn claim, predicated on the restatement of torts from 1965 and the subsequent changes to that. It's really crazy.
Okay.
I have a strong opinion on this.
Professor Hudson, we had one question directed to you. How do you identify the issues that are legitimately in scientific dispute? Historic example from medicine: germs are fiction, the earth is flat, planets rotate in a circle, human flesh is torn from the bone at speeds over 30 miles per hour when trains travel was being developed.
Yeah, that was a probably poor choice of phrase, legitimate. But I guess I'm just trying to say that the scientific process eventually works itself out, right? If the arc of history bends toward justice, the arc of scientific debate bends toward truth, I suppose, in the sense that over time, ideas get vetted enough and scientists try to poke holes in each other's work enough to where you do have a settled, we do know that flesh is not torn from the bone now, right? And so identifying what point in time that is a ex post activity, to be able to look back and say, well, we're there. But I just think about the numbers of, on the wood pellets issue, the number of articles that are published by legitimate forest management or forest scientists that are published in reputable journals, peer-reviewed journals. There's enough of them, in my view, to make that kind of on the side of, well, we're not so sure what the modeling would show or what the climate change impacts of this industry might be. There's enough of them, and it's not just a handful in some predatory journals, that I view that as being a scientific debate. And what I see happening on the other side of, well, there are also some articles showing that it could be bad for the climate to rely on this industry. But I see the advocates from that side cherry picking which data they want to utilize and things like that. So I mean, I think that as with so many of these questions, it goes back to who decides what's a legitimate scientific debate. But I think that we're not doing a very good job of even having the debate right now about trying to hone in on which of these arguments are subject to valid claims on both sides versus ones like Gary talks about GMOs versus 1,000 people dying from organic foods, that are fairly well settled. I mean, I think that's a safe. The facts are the facts if nobody's been harmed from a GMO, and I think that I don't know. I think that can give us some guidance on how to choose between legitimate areas of debate versus ones that are being propped up by vested interests.
Okay.
And I think the other thing is that, unlike the courts where you have a hierarchy and you can get definitive answers, you go up as high as it goes and then that's the definitive answer. There isn't that in science, right? There is not anyone who can pronounce, anyone can make a scientific opinion or publish an article. So you sort of have to look at patterns. You have to look at what the sort of key associations do. What does the National Academy of Sciences say? What does the American Association for the Advancement of Science say? What does the Society of Toxicology say? Those aren't always right, not 100%, but they're very close. And because they're very cautious and they look at the collective science and they only issue an opinion when they think it is clear. You look at the number of publications and where they're published, right? If it's one article in one journal, you shouldn't give it a lot of weight. But if it's a repeated pattern in the very best journals in that field, then you should give it weight. So those are the kind of factors you have to look at because there is not a Supreme Court of science.
And speaking of weight, any of you wish to talk about how judges are applying the Chevron analysis? Just any concerns about that?
Well, I'm on record in my book as saying, Chevron's a problem, right? But Chevron's a problem. It's really the Chevron State Farm interplay. I mean, and this is a federal court, we kind of invert this, right? I mean, we defer, the courts defer, this is current Supreme Court doctrine, and I do think this doctrine is going to be rethought with the Supreme Court we have now. But judges are deferring on interpretations of words, and then they're doing hard look review for deregulatory actions under State Farm. And Merrick Garland's subsequent Harvard Law Review article that fleshed out the review standard, he argued the case, right? I mean, Chevron is a Gorsuch case. His mom was the EPA administrator, and Merrick Garland argued, these things come full circle. Merrick Garland argued State Farm, but effectively on questions of fact, judges are more exacting with a hard look review in practice in many cases than they are on questions of law when they're looking to see if the statute, But really the big problem with Chevron is that it is sometimes overplayed. So I mean, Chevron itself, I think Chevron itself is a defensible holding. Right, I've argued with my friend Richard Epstein about this, but I just think how do you determine, when you're talking about things like smokestacks or stationary sources, I mean, if there's no other definition in the statute, I mean, how do you determine it? So I mean, I think but the problem there is what was going on there, it wasn't a parsing of words, it was just shifting attitudes between the Carter and Reagan administrations, right? I mean, that's all you had. We had changing policy views on what the better regulatory scheme was. They didn't go back to Congress. They took the same statute and changed the approach. And so, the court there wants to say they defer, but there's other situations like Brand X where I think the statute's pretty clear, and I think the Supreme Court probably got it wrong. And so I think if you sort of do with Chevron what the court has recently done with the Seminole Rock Hour line of cases and say, well, we kind of mean it, maybe they can clean that up. But at the end of the day, I think the Administrative Procedure Act kind of gets it right in the sense of saying it's on questions of fact you really want to be deferential. I mean, arbitrary and capricious should be a very deferential standard. And then on questions of law, you should basically review them de novo. Because I mean, I think that should be the real rule. But
well, and I think I don't want to put words in your mouth, but I do feel like the problem is not so much Chevron as how judges use Chevron, and in the sense of in my natural resource law class, we like to do this case NRDC versus Daly, where the lower court found that the Magnuson-Stevens Fishery Conservation Act says that one of the things that the National Marine Fisheries Service is to do is to come up with a quota for a fishery that prevents overfishing, and they approved a quota that by all their own regional fishery management council assessments had an 18% chance of preventing overfishing. And the lower court said, we don't know what that means. They're the experts, they're the scientists, we're going to defer to them. And then it went up on appeal, and the appeals court said, well, only in Superman's Bizarro comic book could policy that's going to have a 82% chance of failure be considered something that should receive deference for preventing overfishing, right? So, and so I think it's just, some of that comes down to just judicial philosophy and how much you're willing to review facts in a deferential manner. Again, I don't know what you do other than Chevron. I think it's a good approach, but I think it's really more of a jurisprudential question of how you view an expert's decision making.
I mean, there's a way you can do it, but it would require 9 people who aren't in this room to do it. And you know, but I have a sort of presumption of liberty standard that I advance in my book, but I very well admit that it's not going to sort of happen. That you basically force Congress to do it. If it's ambiguity, the defendant wins. The government has no power over you if it's ambiguous. The Congress has to be express. And there's ways to do that where Congress can then sort of bring back, you know, the regulatory code and sign off on it. It's not like Congress has to do it de novo. I mean, that's the way trade law is done, for instance, with fast track negotiation. But you know, to me, that should be the standard. Make Congress vote on it. That's what bicameralism and presentment's about in the Constitution. But that's not going to happen.
We should also have world peace.
It's not going to happen. So.
Well, I want to move on to something that has occurred into the readings. In our readings, there's a discussion of the is-ought fallacy, meaning that science describes what is, but cannot solely determine what ought to be. So how do we determine or judge when science and non-science is conflated, or treat the uncertainty embedded in health risk assessments?
Well, I could give, you know, a comment on that. I mean, so that's been a long-standing debate in science, because often scientists want it to be a certain way, and it's not maybe the way it is. And so it's a problem within science to how to control that. And science does have tools and mechanisms to try to peer review and other types of mechanisms to try to squeeze that out. But I think it is problematic in the court system, in the jury system. My wife was a litigator in the breast implant litigation for Dow Corning, and she did this case in Houston that there was a PBS special on. And this study had just come out from the Mayo Clinic and New England Journal of Medicine, finding no risk. And the jurors, though, had given a $4 million verdict to one of the 2 plaintiffs. And they asked the jurors, you know, why did you say this? Well, there was no scientific evidence for this. What about the Mayo study? No, we didn't give that any weight at all. Why did you give the money? Because she needed it. She is sick. She's genuinely sick. And she needs a housekeeper. They used to travel. They can't. She needs the money. It's what it ought to be. Yeah, she should have money, but not from, you know, someone who didn't cause it. And it was interesting because the other plaintiff in the case was even more severely injured, sick, and she actually died 2 weeks after the jury verdict. They gave her 0 because money won't help her. And so they were doing social engineering, you know, with the pocket of money from the defense corporation that hopefully allegedly wouldn't be affected by this, but of course it does overall. It eventually comes back to us to pay for that. But you know, the jury was voting what they wanted it to be, not what it is.
Maybe I'll just take issue with the fallacy to begin with, just in the sense that, you know, we in law, we oftentimes use facts to tell us, you know, facts that are gathered much in the way that scientific process unfolds to tell us what ought to be, in the sense of thinking about equitable decisions and think about nuisance law, for example. And we know that the McCarty's factory is emitting this smoke that's causing the house to turn black and causing the kids to cough and whatnot, and we know that ought not be, and so therefore we're going to come up with an equitable decision to just shut down, to abate the nuisance, right? I mean, so I don't know. I think that I think science can come pretty close to telling you or pointing you in the direction of something. I mean, I think about the city of Houston. I write about this a lot, and when I lived in Houston, we were close to the San Jacinto River, and within about 600 feet of the San Jacinto, they cleared all the timber and filled in some wetlands and did some things, and built a Costco shopping center and a laser tag facility and all these other little shopping center things. And it was in the 100-year floodplain, which means you have a 1% chance of flooding in any given year. It doesn't mean it's only going to flood every 100 years. And so, you know, the way they did it was they built the big, you know, the parking lot on the ground, they built the Costco on the ground. there's reasonable development codes in other locations that say, you have to build up, you have to, build up, put your parking lot underneath, right? And during Hurricane Harvey, that area flooded, and had they built, pursuant to some other development codes, the water would have gone underneath the facility, and so on. And of course, Costco is not going to eat that cost. They're going to put that cost on the consumer, and your, can of beans is going to go up 10 cents or something like that, but that's more like a user fee, which is more of kind of a fair fee. The people who shop at Costco are the ones that pay for the flood mitigation. But we've got a system design where the National Flood Insurance Program or FEMA funds on the back end take some guy living in a mountain in Colorado's tax funds to pay for a poor land use management decision in the Houston area. And so I don't know, I think that knowing that you're in a 100-year floodplain can give you a sense of what ought to be as far as how you should develop your policy. It's just a matter of whether how, the choices that we make regarding the various trade-offs and whether we want to be subsidized by the federal taxpayers for some local development and so on and so forth. So,
yeah, I mean, I think is a useful distinction, and it's a useful distinction particularly for judges. I mean, I think formulating the policy is hard. I don't think that's what judges are particularly well equipped to do with an adversary system with two folks litigating a single case. A classic nuisance case is very much an is case. It's did it cause it? If it caused it and it fits within the contours of nuisance law, you've sort of got your answer. That's very different than saying, oh, well, can we tag ExxonMobil under a grand meta theory of public nuisance with damage from Hurricane Katrina, or in my part of the world in New Bern, North Carolina, Hurricane Florence? That's a much tougher question. I don't think that's a question judges are well equipped to answer. And I think the traditional doctrines, if they're adhered to, kind of work, right? I mean, injury is an is question. Causation is an is question. And it's not just causation, it's proximate causation for a reason. Because this is really designed to be a system of redress that originally was quite narrow. It's been broadened. I think in areas like product liability, it should have been broadened. I think that the modern commercial world we live in is extremely complex, and I think that there are some advantages to product liability law in the general case. I think it's much more problematic when we get to these heavily regulated industries like pharmaceuticals. But I think in the general case there is some value added by product liability. I think a lot less value than some of its proponents claim, and you can sort of trace that. I mean, one of my law professors, George Priest, did this empirical study and traced looking at cars, that you sort of have the pre-expansion of tort and the post-expansion of tort substantive doctrine, and look at safety innovation and what sped it up and what didn't, and you see a slowdown after the expansion of tort. Now that may just be because there's diminishing returns, right? I mean, we don't know for sure, but I do think that the proponents sometimes overplay this. But I do think, just focusing on it, here's the case, here's the facts, we've got a relatively narrow question, and getting the injury and causation right. Now I realize there's sometimes statutes that do away with those sort of traditional standards, and your job is to interpret the statutes. I mean, to some degree, the job of a judge is somewhat a technical one, and it's not a freewheeling policy one, and that's what you're asked to do. And sometimes if the policymakers get it wrong, hopefully they can get it right. I mean, I'm not sure I have enormous confidence in the political system to get it right either, but I think it's at least more legitimate. And I think in the long run, we can overcorrect, but we can correct back in the other direction. Now, the classic climate change is kind of the perfect storm, so to speak, for this, in the sense that the costs are quite long term, and it's also quite a global issue. So the local case is not going to likely fix the issue, and the costs of error could be quite high when you get to these big ticket items of litigation.
Okay, and I'm going to have a 1-minute wrap up by each of you, and then we'll figure out who they are.
Want me to start?
Yes.
So, the courts are criticized a lot for how they deal with science. The Junk Science book by Peter Huber was very influential. It was a great book. I agree with a lot of it. You guys get a lot of flack, but I also think you're incredible, can be useful truth machines. We saw in the recent election, the rhetoric about the fake elections. But when you go to court, you have to have real facts, and they didn't have real facts. And the courts were able to clean that up and try to stop some of the nonsense. There was a claim that intelligent design was a new way of looking at evolution and so on. It had nothing to do with scientific creationism. And it was a federal court in Pennsylvania that showed the authors had just gone through and did a global replace of scientific creation with intelligent design and a number of other things. They lied about it and shot down that policy. And again, all this years of debate in the public domain, and the courts cleaned it up with one case because they had discovery, they had testimony under oath, and were able to get to the facts. And then what I like on GMOs is that a lot of the organic food sites, and including the New York Times and documentaries, have been saying Monsanto sues farmers who get accidental contamination of their land as a patent violation. And they then made the mistake of suing Monsanto to stop them from doing it, even though Monsanto says we don't do that. And so Monsanto just turned around and says, give us an example. And so I'm on all these email lists, these panicky emails go out, we've got to find an example. This guy said it, and they asked this guy, says, no, I heard it from this guy, I heard it from this guy. They didn't have a single example. They couldn't come up with a single example, so the New York Federal District Court dismissed it and went to the Second Circuit, dismissed, because they couldn't find a simple example of the practice they were claiming in the public domain. The Monsanto was doing it, was all over the media, and it was a complete farce. And the courts are the one institution that cleaned that up.
Thank you, Professor Hudson.
Yeah, this may be the least practical, suggestion I could make, but I think it's great to look for clerks that have some scientific training and expertise, and can be tasked with, much like this case that I mentioned about the forest fires, that can be tasked with, can you, as part of your legal analysis or your research, can you help figure out the legitimacy of this debate from a scientific perspective, and that can help inform judges on what's junk science versus what are the National Academy of Sciences saying, and what's more grounds for debate. I think had something like that taken place in this Cascade case, they would see, wait a second, this is pretty settled that these type of forest management approach, just because there's a couple of articles out there that you didn't consider that say, well, it could cause the other problem, that doesn't mean that you should not defer to the agency. I think that hiring people with some expertise in the scientific realm, I think, is a helpful approach.
Thank you. All right.
Yeah, just a few points based on sort of summing what I said earlier. First of all, the rules matter. I mean, the theme of my book, again, the unelected get it. I recommend it, but the theme of my book is that these things all intersect, and so it's not just evidentiary rules. It's civil procedure rules as well as substance, as well as fees, as well as damages. I mean, all these things interplay, and so evidence is only going to be a small piece of that. Two, the lay jury can get things wrong. I think lay juries usually actually do a pretty darn good job in terms of what's presented with them, but the outlier jury can override the others. 10 juries can get it right, and then the 11th jury, if you've got unconstrained, non-economic and punitive damages, can effectively override the other 10. So cabining what's in front of the jury is part of the judicial craft, and that's sort of what Peter was arguing for. It's sort of what the Daubert rule and its progeny are designed to sort of get there, focusing the jury on questions that it really can answer, and remembering that sort of presumption of liberty that this is the government use of force, taking from one side and giving money to the other in most of these cases, important to keep in mind. And third, think about the administrative agency stuff really carefully. Tort law can override it and can make a mess of something that may already be messy, but tort law can make it worse. And fourth, sort of the public health consequences can be massive here, so they're big. But again, to some degree, the policymakers are going to have to fix some of this stuff. But some of the old rules actually make sense if they're applied.
Okay, so from this group, who is the all-American skeet shooter off this panel? Wrong.
Just because I'm from Alabama doesn't mean.
Okay, so you all had one guess. Let's see over here. Wrong. All right, we have it right here. Okay, next, who grew up in a commune? Let's try that group over there. Wrong.
I did. British
Marchant.
Columbia,
Okay, so process of elimination, who's the basketball player?
And if you listen carefully, you knew that wasn't me because I went to UNC. And he went to Duke, but only for law school.
That's right.
All right, so thank our
Correct them when they
panelists.
assume that I play basketball at Duke.